Let's bring in National Trial Attorney Michael Jaafar, who is standing by watching this with us. We've hit the pause button on that testimony. But, Michael, I want to ask you about this video. We keep seeing it over and over again in evidence. And typically, when there is video of an incident, the defense doesn't want to get it played over and over, and the prosecution wants to show it as much. What do you think about the repeated showing of this particular video?
They're playing the cards that they were dealt. Right? They have a good card, they have a good ace in the hand, and they want to play it. Because you look at all the evidence, obviously, before a trial starts, both the prosecution and the defense, and you look at all the various evidence that helps you and doesn't help you. So if for the defense to keep playing the video, I must assume that the video helps them or helps an element that they're trying to prove. They're clearly right now trying to prove the point that, hey, why did you say that you were scared, but here in this video you're laughing? You weren't scared. Why weren't you scared? Is it because more people showed up? And so they want to show that, hey, more people showed up on their side, and so they had no reason to be afraid. Our client did have a reason to be afraid. Our client admittedly killed somebody with a knife, but he didn't do it because he's a sociopath. He did it because he was afraid, and here's the evidence of why he was afraid.
Yeah, and this has been the theme with all the cross-examinations of these witnesses that were there. Defense really trying to get across that you guys were picking on this person. You weren't scared, you were laughing. And then hoping the jury's going to make that leap to he was scared and he was being,
encircling, surrounding. They want to show that they didn't give him any opportunity to leave.
Yeah, and the video does seem to back that up. In fact, we're going to get a break in here, but coming up, this witness will be asked, are you trying to tailor your testimony to fit the video? We'll see what the reaction to that question is when we come back. All right, let's, that was it for the morning session. We're a little bit behind, but they're still at lunch there in Wisconsin. And boy, some compelling testimony from these kids. Now, I guess young adults, but at the time, absolute kids.
You can see in his face just what it was like going back to that moment, to seeing your friend stabbed, learning that he was killed. It's difficult all around.
Yeah, absolutely. Michael Jaaffar's watching along with us. And Michael, what are your overall thoughts of this case, this self-defense claim by the defense? If you're defending Nikolai, how would you go about getting this across to the defense and trying to get your client's story across? Do you have to put him on?
I absolutely. So if my client in this case has a good, clean background and didn't serve 25 years for stabbing somebody else, I would absolutely put him on. And I'll tell you why. That cross-examination that we just witnessed was very effective. It basically kind of established some of the things in the opening statement for the defense, because their opening statement and their theory of the case is he was defending himself. His life was in danger, and this kid, under cross-examination, admitted that the guy got basically knocked out in the water, right, by people who were, basically stronger than him. So that was a very effective cross-examination. If I was a defense, obviously, on day one, I would wish that the events happened with a gun, not a knife, because with a gun, you could make the defense that you can make the argument that, hey, it was quick. My client had to act. He didn't know if his life was in danger. They could have taken his gun and killed him, but obviously it's with a knife. So with a knife, it's a lot more difficult for the defense because it's more intimate. The chances for retreat are more. So that's the challenge, but that was a very effective cross-examination. So to answer your question, Ted, if my client has a clean background, given the way the testimony is going now, I would absolutely put him on, and he'd just say I was in fear for my life.
Which our understanding is he is someone who does not have a criminal record. That's something his defense has put out there. Someone who, up until this point, had not been in any altercation that we know of that is similar to this one. Do you think, based on what we know, Michael, about this case, that prosecutors could have charged this differently? We're talking about first-degree intentional homicide is what they are saying for this particular situation, knowing that charges in different states is different in the way that they approach them, but we do at least have first-degree and second-degree in Massachusetts.
That puzzled me, to be quite frank. That puzzled me. I think it's an overcharge. Because when you look at the facts and there's a video there, you make the charges that you think are going to stick. You don't want to overcharge, because prosecutors usually overcharge, Julia, on petty crimes, right? Possession of 1 ounce, they'll charge you with maybe 2 ounces, right? So they'll do that because they know that those cases almost invariably plea out, right? This is just not one of those cases. I'm always puzzled by overcharging cases when you know that they're going to be a high-profile case. I mean, given the facts, you should know that this is going to be a high-profile case. I think that was an overcharge. And in my opinion, I think a second-degree murder still would have been very, very, very difficult. And maybe that was their thinking is, hey, we have families of victims and we have to kind of report to them and show them that we're doing the best we can. But I think it was an overcharge.
Yeah, I wouldn't be surprised if lesser includeds will be on that menu list for jurors. And at the end of the day, they know in the back of their mind, let's go for 1, but we're probably going to get some sort of manslaughter scenario.
I'm not sure that's about how it's supposed to work, though. They, as the prosecution, need to look at the context of this case, but we're seeing it all play out just as the jury is.
Yeah.